Well, welcome to this episode of The Dental Guys. I'm Wes, the Dental Guy.
And I'm John, the Dental Guy. Here we are, Wes. It's another brand new, fresh episode. I'm ready.
Man, listen, are you texting us? Right, John? I want to hear from people that, right, have questions, comments, suggestions. What kind of favorite food in Charlotte, North Carolina did John and Wes have? Did we have another Asian hair experience? Wait. Listen, AO was amazing. I know it. We're recording this prior to even getting there, and we're talking about how amazing it's going to be.
Oh, yeah. Because we know by the time this releases, everybody's going to have seen who we've had on. They're going to know kind of who we interviewed, who we talked to. And you know, Wes's reference there.
If you've been listening to Dental Guys since the beginning, you know. Text us if you know what we're talking about.
One of these days, we might have to retell that for our new listeners. One of these days, not today, but I mean, just suffice to say that a waitress may or may not have caught her hair on fire while serving us dinner at an AO meeting a few years ago. So just tie your hair up, ladies. That's all I'm going to say. If you're around candles, tie your hair up. But
that's awesome.
Yeah, I mean, I know it's going to be amazing, and to me, this time of the year also, I mean, there's a lot of big meetings going on. And so, yeah, text us about what we learned. If there's things that you say, hey, I saw this, you guys were interviewed so-and-so, I want you to release that footage. Because, we're going to have to decide, Wes, after this meeting, what do we release? Because we're going to have a lot of content.
Let me just tell you right now, it's going to be amazing, right? And there's going to be so much content that's going to be coming out after this. And I'm sure you've probably listened to the AO recap a couple weeks ago and what we talked a little bit about, like the theme of the show and how it impacted us in our practices. Wait for the AO recap. That's going to be amazing. But what I would say is what's to come down the road here, because there's going to be some amazing. Who do you want to see? Who do you want to hear? 865-544-8954. That's how you get a hold of the Dental Guys, right? Text us your questions and answers. John?
Yeah, let us know what you want to hear more of. And as we, go forward, we promise you when we release this new season that we were going to bring you things we've never brought you before. And we have one of those guests with us today. But before we get to that, I just want to talk a little bit about how good it is to have a sponsor like the Dental Crafters Network. When you are day in, day out your practice looking for partners in a lab that can do what you need, how you need, when you need, or maybe even to redirect you to doing things at a higher level. Dental Crafters, built on a foundation of unwavering dedication and respect. The Dental Crafters Network is a family-owned dental laboratory with 30-plus years of history, enriching the customer experience through their core values, responsiveness, versatility, and trust. They collaborate with you to meet your patients' unique needs. Experience the difference. And listeners, this is big. Receive 10% off your first case when you tell them the Dental Guys sent you. Call the Dental Crafters Network today at 1-800-472-8302 or visit dentalcrafters.net. And we are so happy to have the Dental Crafters Network on as a sponsor. So without further ado, we want to bring on our special guest tonight. And we're really excited to have Corey Shipley on with us as we get into this episode of the Dental Guys. Welcome, Corey.
Hey, guys. I'm really excited to be here, and I appreciate y'all having me.
Yeah, absolutely.
Corey,
and
we are excited to have you on the show. And this show is live recorded. And I have to say is that this is the first time that we've had an attorney on our show. And I'm super pumped about this because there's a lot of questions out there. Now, also, I want you to tell us a little bit about yourself, and you do some things on the side that has to do with using a mic, maybe Friday Night Lights, right? So you have some training. Yes. And if you wouldn't mind, just center up on the screen, because normally you're not seen. You're heard from behind the scenes. So center up on the screen. Tell us a little bit about like yourself, how you started, and how we really brought you on here to help dentists out. We're super pumped about that.
Well, Wes, you're right. I do a little bit of color commentary on Friday nights, so it's something I've been doing for about, I don't know, 5 to 6 years now, and I really enjoy it. Just get out and get to watch some football and talk about something that I know a little bit about. But I practice in Greenville, Tennessee, at the law firm of Collins Shipley. We we started our practice back in 2017, right after I left the United States Attorney's Office. With my law partner, Kirk Collins, we started our practice then, and being in a small town, as John and I have talked about it, quite a bit in the past, it's kind of hard to really focus on, one particular thing until you can get really good at it. But we do a very general practice, really heavy litigation. So I'm in the courtroom, I would say 3 to 4 times a week, and John gets to hear that a lot, and I see him at soccer games on the weekends. So how I've been in court till 6 o'clock. But we focus. I do a lot of trial work, so I think that hopefully that I can, at least talk about a few things that may help some of your listeners based on some of my experiences.
That's awesome.
Yeah, I've known Corey for quite some time, and I've gotten to hear some of the trials he's been involved with, which are, again, to us, much like anybody looking in from the outside. It's kind of just like, wow, that's something that I know very little about, but very interesting. But unlike dentistry, most people aren't making TV shows about dentistry, dramatizing the excitement of the dental operatory and room, but yet everybody's very interested, I think, or many people, in the courtroom, because I think part of that is the unknown, part of that is the stakes are high. And, I want to maybe, as we kind of start into this, I want to just give a little quick disclaimer just from me to our listeners. We're going to talk about some legal stuff. This is not like legal advice for you and like every situation obviously is different, right? So this is just for information, just so y'all know you're hopefully not making decisions on your day-to-day life based on what we're going to talk about. But hopefully we can give you some just enlighten us a little bit on what's happening. So Corey, dentists are often, I think, at least I know I am, I think Wes is, we're intimidated by anything legal. We hear the word attorney being mentioned in our world, and immediately we're like, the hair stands up on the back of our neck, like, oh, that sounds bad. And, why do you think it is that in our profession and many medical professions as well, that is something that is commonly, people are just afraid or just intimidated by it?
Well, that's a really good question, and it's I'll give you my best guess, because obviously I'm on this side of the fence. So sometimes I really don't know. But I mean, I think what you said, and you kind of touched on a little bit about just kind of the unknown. And I think we live in a society that's a very litigious society. I mean, you think people getting sued for everything, and what I think that does is, I think when you hear uh, you know something about an attorney, or see a letter from an attorney, or whatever you may however you may encounter that, I think that it's just the worry of, oh, you're always looking over your shoulder. Have I done something wrong? Because hindsight being 2020, it's a lot easier to judge something when you've got to make real time decisions. And so I think that's a big part of it. I think that because everybody files lawsuits for everything anymore, and sometimes lawsuits are, believe it or not, they do lack merit at sometimes. So I think that's what it really stems from. And and when you all, I'm sure, when you're doing surgery on someone, I mean, it's not really unlike me being in the courtroom, because you have to make split-second decisions on your feet, and use your best practices. And it's hard for someone to come in and judge you on that. Like, unlike me, if I'm in the courtroom, I really don't get judged after the fact, other than, I guess, by the judge on the ultimate presentation of my case. But you all are always being second guessed, and I mean, in the profession that you're in. So I think that, I mean, not many attorneys are calling your office wanting to take you to lunch. I mean, even though I may take you all to lunch one day, but it's not something that you normally would see, is somebody just calling you to just to chat about whatever.
I think as a follow up to that, even today, a lot of patients use intimidating remarks to try to create a reaction in you that may not be the right reaction, or maybe the wrong reaction, and maybe it is right. So, without talking about specifics, when patients most of the time call and the blame game starts about they said this and this didn't happen, and and really most of them want something, right? And you have maybe another dentist that has offered them some advice on what to say whenever they call back to the office. And in the midst of it, you're practicing. I'm back, doing procedure, and you step away. And a lot of times the intimidation is I walk into my office just for a short break, maybe to grab a drink of water in between a patient, and your office manager walks in and says, "Hey, this person called. They're really upset. This is the situation." And you're left with a decision. And, well, what should I do? Should I just refund them the entire case money and just say, we're just going to send them on down the road, because you fear, right? You fear litigation. You fear someone actually saying, well, what you did was wrong, and then them taking you to court. How do you recommend that dentists just handle the day in, day out, discussions around intimidating patients? I mean, I'm just going to call it that, because they are intimidating when they start throwing out idle threats about hey, I'm upset if he doesn't do this, I'm going to do this.
Wes, that's a tough question. But again, it kind of goes back to kind of where we started about just people wanting to sue for everything. I mean, as you all know, I mean, it's really hard to make everybody happy. And, I think where that comes in, and, people that have these opinions about, what they've had done to them, and whether or not it's aesthetically pleasing to them, or what have you. I mean, I think that's where it comes into, taking pride in your job, and doing the right thing, and knowing, making sure you're doing the best thing that you can do for some of these patients that you have. And again, I think that's where the similarities with our jobs do align a little bit, because we have people sometimes that will represent that, that may not get the outcome that they wanted, but we have done the best job that we can do. And I feel like that, when you're confident in that, and you go in and you're well prepared, and you're up on the most current technology, or you've read the most recent literature, and just really making sure that you're doing what a reasonably prudent physician, a doctor in your similarly situated area or position would do. I think that it comes to a point where you have to draw the line somewhere. And by that I mean, if you're constantly just having that reputation of, hey, just go make an empty threat to this doctor and he or she will just refund your money, I think it comes to making sure that you're confident in the work that you're doing, and if you are doing a good job, and you do a good job. So I think that there's a fine line. I mean, if it's something that can be easily refunded, I mean, yeah, maybe that's a little bit different story. But if you did a good job, I think that's where you really kind of have to just kind of stand strong and say, look, we
John,
making sure that.
This is good advice, and Corey, I didn't mean to interrupt you there, but this is exactly what we need to hear. Yep. What you said there, and what he said, John, is you need to know what you're doing. You need to have been reading the most recent literature. You need to be studied. You need to be confident. And here's what happened today. I had my treatment planning coordinator there. I walked by, I was drinking a glass of water, and they were just like, come in. They were in the big house, and I walked into the big room, and there was the new financial coordinator, and she was training with the treatment planning coordinator. My manager's standing there, and you can tell my manager's really upset because she got off the phone. Not bad upset, but I mean, they were like, "Can you receive some information right now?" I'm like, "Yeah, I'm good." I'm like, and so they told me this story, and I said, "Well, what do you all think?" And they were like, You did an amazing job, and we have before and after pictures of what you did here, and we think you should stand your ground on this and don't back in. And here's our response and what we've already thinking about telling her. Do you agree to that? And I'm like, I think it's perfect, it's helping me because I'm confident that we did a good job, and my team's behind me because they know I'm well read, John. And we talk
Mm-hmm.
about this all the time, John. You have to
Yeah.
know your craft.
Yeah, that's the first thing, that our show's been about from the beginning is, it's about trying to take your practice to the next level. So where you are, first of all, in that position of being able to say, hey, I know what I'm doing because I went to the right education courses. I read the right literature. I have had experience and I know how this is supposed to go. And I think that if you have that, then I think depending on how you process information, some of us are thinker first, some of
Mm-hmm.
us are feeler first. And I think depending on how your personality works, if you are a feeler first, you tend to be like, man, how's that person feeling about what happened? You
Yeah.
become, sometimes you can really take burdens upon yourself, but we have to be able to say, hey, we've done the right thing. We have done everything the way we should have done it. So if a patient's upset, that's going to happen. Life is imperfect. So can we with good conscience say that this is a good outcome, as good as it could be, or hey, things do happen? And I think it's a good word from Corey to kind of hear that. And I think as we're kind of unpacking that a little bit, because as people start hearing these things, Corey, they start thinking, okay, so that's good. If I know, if I got a patient who's upset, I can rest on my skills. I can rest on my experience. I can rest on the quality of what I've done. But there's all of these terms, I think, that start to come into play that we maybe get like some basic courses on in dental school about, okay, well, what's malpractice and what's the difference in malpractice and standard of care and negligence and all these all these terms that I think become very confusing to a lot of us as to when do we need to be worried and what do we need to be worried about. And if something goes wrong during a treatment, the question is, well, when does that become a big problem and when is it malpractice? And what's the difference between, things happen and malpractice? And what's the difference between malpractice and negligence? And what does it even mean with standard of care? Now that's a lot of questions there. So maybe let's just start with definition of some terms. What does malpractice mean? And maybe what's the difference between, say a malpractice claim and a claim of like negligence, like actually doing something either, wrongful, in a way that was purposeful or what have you, just kind of start maybe educating us a little bit on what are some of the things you start thinking about from your side of things when it comes to some of this terminology.
So there are situations or times that I'll get calls in my office for potential medical malpractice cases, dental malpractice cases, and I don't really do a lot of that. I mean, yes, if it's something that I think that is just such a breach of the standard of care, then yeah, I'll take a look at it. But um, one thing I will say, and just circling back just a few minutes about some of the minor things that that may go wrong, I do think that something that doctors in your position or other people's position, I think that the paperwork that they sign at the beginning before a procedure is very important on
Mm.
the risks of the procedure, and I think what we do is we live in a society of just people that are impatient and we just kind of want to turn everything over and get it done quickly. But I think making sure that each patient that you have understands what kind of as best they can of just the potential the minor things that could go wrong during a procedure, because then if you say that if you're going to have a procedure done and these are the potential risks that could happen, then at the end of the day, I mean, they don't have to have that procedure. I mean, they have undertaken that risk, so that's a little bit of an assumption of risk there. But going back to what you asked, and that was just a little bit of commentary that came to my mind, something that could hopefully be useful. uh, I started thinking about when it comes to malpractice and negligence and really trying to figure out what the best way to describe that to some of the listeners would be. And I think it really comes down, I mean, they have such a, uh, they're not really that different, but I think it comes down to, when it comes to just like to say medical negligence and something that is really unintentional, that say that, you may do something. I mean, I don't know if you're doing a filling or something like that, and you nick someone's gum or something like that, and they bleed a little bit, so something that's unintentional, like that's something that you didn't intend to happen. Now, should it have happened? Probably, maybe not. But I think that's where the question comes into play. But looking through it and doing a little bit of reading on some commentary today, finding out, but malpractice is a little different because it's more of an intent. And I know that sounds a little crazy, and I'm not saying that anybody in your profession intends to harm anyone. I'm not saying that, and that's not what I mean. But it's more of a situation of you know what to do, you know what you should be doing. You assess the X-rays or whatever you do, and this is what you should do, or you should recommend that your patient does X, Y, and Z. You should do that. Well, you get a call from someone saying, "Hey, I've got a meeting or meet me for dinner tonight," and you just don't do that. Like that you should do it, but you don't do it. Like a failure to diagnose or something like that. So you are well read. You understand kind of what the procedure should be, but then you choose not to do it. So I think there's a difference in that. So when I say they're similar, you still have like the four things that you must prove. The duty, breach, causation, and damages that are really present in every tort case, because that's what we're talking about. It's just a portion of the law. It's tort law, and I think that that's the difference. And as I was reading, just trying to look at that, and trying to figure out that, like, when you do a medical malpractice situation, what you should be doing. Based on what you've learned, and you are expected to know this, and you just really choose not to do it. So I think that's kind of the difference in when it comes to those two. Now, you still have to prove it in the same way. And going into something else you said, John, when it comes to standard of care, and standard of care and negligence, malpractice. I mean, that's usually what we see is proven by expert testimony. So you have to get other practitioners that understand what the standard of care is in your region. I mean, because the standard of care in East Tennessee may be different than Northern California. So you're really not going to see many. If you have a case here in Eastern Tennessee, you're not going to see many experts from Northern California that are going to come here that can testify as to what the standard of care is. But I thought that it was really interesting when it comes to that, because if malpractice to me is it's almost a little higher standard, because again, what you should be doing and you just neglect to do it, whereas negligence really could be just a mistake.
Mm-hmm. Mm-hmm. And that's an important distinction, I think. And when we start to go down that road a little bit further, and you think, that is important, I think, for our listeners to hear that, a mistake that happened that wasn't supposed to happen, it goes back to trying to define what at the beginning of the procedure could happen, and it doesn't happen often. But like you say, I mean, if you've explained risks versus benefits of the procedure to this patient, and one of those risks that you've discussed does happen, even though you don't want it to happen, it's a different story than, you just decided to skip a step, or you just decided to, do something wrong. And I think every dentist listening to this knows very easy, examples of this, right? If you don't use a rubber dam while you're doing a root canal, and, somebody swallows an instrument, you have no defense against that, because you knew what you should have been doing and you made a choice to skip a step. And so you really can't have a defense with that. So I want to talk through that a little bit, because I think most of us, with that definition, Corey, it helps us understand the differences. So let's say that we get into a situation where we're either, somebody's threatening to do something, or maybe we receive a letter from an attorney that's threatening toward legal action, right? So we feel like, man, this, whether or not it has merit, what should we do? What's the next step that a clinician should take? Because a lot of times I think we, like Wes said, we kind of try to think, well, should we handle this ourselves, sort of internally, or should we call the patient, or what's the next thing to do? When do we involve, say, our malpractice insurance carrier? When do we involve, legal counsel? What would you say to that?
I think if you receive a letter or something from a patient, I mean, I do think it's okay to reach out to him or her, talk through it a little bit, see what the level of disgruntledness is from that person. But what I would recommend, if you do receive notice from an attorney stating that on such and such date this happened, and that they're threatening potential legal action, I think that's something that I would recommend that each person listening to this really looks at their, and I know it's something that you probably do. You look at your malpractice policy, and it's just like, each year you wonder what your premium is, and wonder how many other doctors you're paying for, and you look at that. So, but and I know that's typically the way it happens, because I find myself sometimes doing that. And but what I would recommend that you do is, number one, I think you really need to understand what you're agreeing to from an insurance policy, and really look at that and see what your duties are. Because I will tell you that, and I have experienced that, and I guess heard from people that have had to experience, whether it be doctors or whomever else, that have a malpractice claim. Uh, you almost have a duty to inform your malpractice carrier that there is a potential claim. And I think that's very important. And I think it's one of those things, kind of going back to how we first started here. But you're prepared, you do what you should do, and I think that's why you have the malpractice insurance. Because what you do is that you make sure that your carrier is on notice immediately. Because what you don't want to do is, now we're assuming, for the sake of argument here, that the claim really has no merit. But if it, because what we wouldn't want to happen is, if the claim does have merit and you decide to, well, I'm just going to have to deal with this myself, or talk to a friend of mine, that way he or she can give me some advice. What happens is that's when your carrier can come in and say, well, you didn't give me timely notice, and therefore we're not going to defend you. So out of your pocket now, you're actually paying an attorney thousands of dollars to come in and defend you, rendering your malpractice policy basically moot. It means nothing, because they can say, well, you didn't do X, Y, and Z, and therefore we're not going to provide coverage. And that's the worst case scenario. But I will say this though, there's nothing wrong with, if you do have friends, or you do have friends that are attorneys, like consulting with them, because there's nothing in the policy that says you can't, if you chose to, you can go out and hire your own attorney, and that's, you either choose to use your malpractice policy or not. But there's nothing that says that you can't, consult with people that you trust on what they believe, if the claim has merits or not. But I would just recommend that in any time that you receive any type of threatening letter from a lawyer, always, 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 always put your malpractice carrier on notice, because then they can't. Now, whether or not that proceeds anywhere or not, you have fulfilled your first obligation under that policy in the event something does go awry. So I think that's something that you really should do. Again, uh, get the advice from the people that are closest to you. Absolutely, I think you have to do that. But I think at the end of the day, it's better for you and better for all involved if you do that, because then that just kind of checks a box off that they can't come back later and say, well, you didn't do what your policy said you should do.
Right, and I think that's great advice, because if, like you said, it's rare that because most people are trying to do the right thing. Most doctors are, I believe, hopefully, are trying to do the right thing. And if there is a letter that shows up on your desk, and you call your malpractice, company, whoever's who your policy's for or held by, you're going to speak to an attorney very quickly. I know this because there was a point in time in my career where I did receive a letter from an attorney, and I called them immediately, because that's just what you're supposed to do. You call them immediately, and you're nervous inside. You're going to feel that, right? You're going to feel there's some angst, because you're like, what in the world did I do wrong? You start like going through your notes, and you're like, did everything get documented? Like, all those are normal feelings. And I don't think anybody that's listening to this, you're going to have that happen maybe once or twice in your career, where you get something on your desk and you're like, and you're like, oh, is everything in order? Just call your malpractice attorney, because I'll tell you right now, most of these people are highly trained and highly skilled, and they immediately answered their questions. They asked a few questions about what the letter shows, what it says, all these things. And in my instance, it was something that wasn't malpractice. It was like a civil lawsuit situation where somebody was trying to sue me for money that they said that they had a right to, like they had overpaid, and I owed them money, and they had an argument about an account. Talk a little bit about that. Is like what happens then? The malpractice attorney sees, okay, Wes, this is not really malpractice. You need to hire somebody to handle this locally. Tell us about how that would go.
You're exactly right, because at that point in time, the adjuster or the attorney or whoever you talk with at your insurance company will have notated that you have put them on notice. So that's check that box. So what they do is that you're right, because they're highly skilled, and because that's what they do. You have these insurance companies. Your carrier chooses to have these attorneys that know exactly really how to spot malpractice, know exactly how to differentiate between a kind of a quasi contract claim that you may be describing a little bit there, Wes, about it's a payment or overpayment. But what they can do is that the attorneys, if it is somewhat on the somewhere within the spectrum of potential malpractice, they have experts that they can call on, that they can just say, hey, what we're doing is we want you to look at this. This is what happened. Is this something that we need to take action on right now? If they deem it to be, it's not a malpractice case and you need to go hire your own attorney, then that's different. Because then you can go and you can say, look, Corey, you call up and say, Corey, I've got a contract dispute with a patient. We're arguing over the services rendered. They believe that they overpaid. I believe that this is what my standard practice is. My first question to you is well, what's your contract state? Did you tell them what it was going to be? Did they pay it? Did they pay under protest? And things like that. But I mean, that there's a difference. But the thing is that I would just state that that's not something that professionals in your area that I would recommend that you all do is try to make that decision yourself, whether or not it's malpractice or whether or not it's a regular civil claim. Just like for me, I mean, I enjoy talking about dentistry with John. I mean, we do that oftentimes, but it's just like I wouldn't feel comfortable coming into your office and trying to decide whether or not this is a root canal or an extraction. I wouldn't want to do that because I'm not qualified to do that. So I think that's really important that you all, still contact your malpractice carrier, even though it may be something minor that's not considered, medical malpractice or medical negligence that would even get close to even triggering the standard of care. But you still have someone else that's making that decision for you that ultimately you're going to protect yourself. I think that, and at the end of the day, I mean, that's what you're wanting to do anyway. Or it's what any professional wants to do, that make sure that when he or she's rendering these services, that you're doing the best you can and being the best at it that you can be. And I think that if someone calls that into question, and the manner in which that lawsuit may be filed, may not be filed, that's a decision that your carrier should make. Because then you can have some comfort in knowing that I've done what I need to do. I've put the proper people on notice, and let them figure it out.
Yep.
And then you start worrying about your next patient, your next consult.
That's right.
Right.
That's right.
Right.
Good.
And get that off your plate a little bit more. So I guess then, oftentimes when we get to having these discussions, about you receive the letter, you may talk to your malpractice carrier, and let's say that there's a question as to whether the quote case that's going to be brought against you is with merit or without merit. Oftentimes you hear discussions about how these carriers will handle these types of claims, as to whether they'll say, we're going to recommend that you settle this, basically to just, not necessarily admit fault, but, provide a financial settlement, if you will, that in order to avoid taking this, escalating this. And sometimes you hear about cases where, hey, this is something worth fighting about or worth fighting for, quote unquote, taking this to a trial situation or further. And having been in a trial situation multiple times, Corey, more than most attorneys that I know you're very comfortable in that world. And my understanding, talking with you and other attorneys that I've known over the years, is that some, are more comfortable with that and some are not. But I wonder how do you, and this may be something you can speak to or not, but I'm just interested to know what your thoughts are on, how do you think that these carriers make decisions on, and as dentists, I guess one of the things we think about is, when someone accuses you of something, right? Your tendency, I think, many times is to want to fight, is to go, well, no, like I want to prove myself right here or innocent or whatever the word is. And, is that the best approach? Or is this, I mean, obviously I know it's going to be completely case by case. You can't make some blanket statement, but maybe speak a little bit to how some of these decisions get made. What should our mindset be as we're discussing that maybe with our carrier or with a malpractice attorney? How are some of these decisions made?
Just as an example of some of the medical malpractice cases that I've been involved in medical malpractice cases when, doctors, medical doctors that are being questioned, surgeons. I've actually been involved in a dental malpractice case. So, I mean, I do have a little bit of experience when it comes to that. And, what I would do in a situation where if a lawsuit gets filed, let's just say for hypothetically, you're past the phase of the letter. You've called your malpractice carrier. Then the next thing you receive, which sends off many more red flags than a letter, is a summons and a complaint stating that you've been sued. What I would do, first of all, I would start doing the discovery process, doing the depositions and everything else. I would depose the doctor that we sued, and the other side would depose the patient to see what the damages were. But the next thing I would do is that I would depose an expert in the field that practices a very similar practice that's the subject of the discussion. I would do that, and I say that just as an example because as an insurance carrier, based on what I know now, I've never defended a medical malpractice case, but what I understand it to be is that they're looking at this and they are your carrier, their attorneys, they're consulting with experts around the clock. And what happens is that that's where you really have to put some faith in your legal counsel and say, look, you all need to assess this, and you need to assess this from you're asking your experts, then you're looking at, this is what happened, these are the medical records that support this, these are my decisions. You've documented well, your note taking is very good, you're very thorough in that. You do exactly what we're talking about when it comes to it's like I said, the note taking and making sure that you're being very thorough. But what happens is that's something that you really shouldn't worry about that much when it comes to the overall merits of the case, because that's where the experts are going to be able to come in, and that's where the lawyer is going to be able to come in and say, look, John, this is what happened. This is where our case is very weak. If we want to settle this for a reasonable amount, it may cut down on the risk. But see, that's the interest. One of the many interesting things about law is that it is such a gamble. It is such a gamble when it comes to trial work, because you don't know what's going to happen, because typically this is in front of a jury, and it really depends on if your lawyer is good enough where he or she can educate the jury on a very complex subject such as dentistry and the intricacies of dentistry. So I'm in a position where I will always let my client make that decision, whether or not he or she feels comfortable about going forward with it. But I'm not really afraid to go to trial either.
Well,
so
let me maybe ask it this way, because I'm going to maybe poke the bear just a little bit on this, okay? And because I think that's what we want to try to do here. Maybe a better way for me to phrase that, because I think you've answered 90% of that. But
sure,
my more pointed question is, are they looking at it and going, okay, you know what, Dr. Rogers may be right, and we could win this case, but it's going to cost us $25,000 in legal fees. But if we settle it, it's only going to cost us $5,000. And is that what's happening? Is this just, it's like recalls on a car, right? They go, well, it costs us $100 million to do the recall, or we're going to settle a certain number of lawsuits for people that get injured because of this defective part. And that only costs us 10% of that. So we're just going to accept, rather than spend all the money, we're going to accept a loss. Because I guess that's where like as us being like, well, we want to be right, we want to be found, but is this a money decision that the insurance carrier is making, or is this truly a benefit to the clinician or to the insured in these situations? Should we be happy if we settle a claim rather than go to court, or should we be like, man, we should take this all the way and quote clear our name? Or is it equally damaging, to our just simply the fact we were involved in a lawsuit that went to trial? Does the potential, court of public opinion maybe matter more? That's a little bit more provocative, but I feel like it's something that we often wonder is like, is the insurance company really defending us, or are they defending themselves?
Well, there's a lot to unpack there.
I told you I was going to put it there.
I think that, unfortunately, I think it does come down to a numbers game at times. I really do. And your example, you kind of hit the nail on the head there on in multiple ways, because, I mean, yes, if it's going to cost you $25,000 to defend the case, and now that's different, but when your malpractice carrier is paying, that's what you're paying the premiums for. But yes, I mean, if it's going to cost X amount of dollars to defend the case, and it's going to take $25,000, $30,000 to do the depositions, to do the expert depositions, to do the discovery, go through all the written responses and everything, but they're saying, well, we can get this settled for $5,000. Sometimes you just have to, just look at the cost benefit analysis of that and realize that if you settle it for $5,000, do a non-disclosure agreement where it can't be talked about and the case goes away. It's not a terrible way to handle something, because I've seen trials that have happened where you said something about the court of public opinion, but when you go to a trial and this is something, or get into litigation when it comes to, and I keep talking about depositions, and that's the first time that you're going to be sitting across from an attorney answering questions. There are no secrets anymore. I mean, your life is just completely an open book, and I think that's one of those things that's very attractive to some people that say that, look, I just want to settle this, make it go away. Now, you don't want to just always give in to that and say that, because if you are right and it's a principle thing, because I will tell you, malpractice attorneys that will defend these cases are very good at what they do, and what they'll do is that they they'll turn the heat up on these plaintiffs' attorneys that may try to sue you and get some type of think that they can get a quick settlement. They'll kind of turn it up on them and making sure that they can kind of push them to, see that their claim is meritless. And there are also other procedures, John, that I will tell you that can be done. That's pre-trial. That I will tell you, if a claim just has no merit whatsoever, there are certain pre-trial motions and things like that can be filed that can get the case dismissed even before going to trial. So I did want to clarify that. So it's not just a situation where if a lawsuit's filed, then the next time you're going to court is a trial. There are certain things that can be done that these malpractice attorneys are very good at finding the claims that have no merit. So, but the thing is, at the end of the day, it is a money game. And you said something about the recalls on a car. I remember in law school we studied a case where I forget which car company it was, but there's an issue with the gas tank, and the gas tank was malfunctioning, and there have been reports of a couple of these cars just completely blowing up, and it was a clear product liability case. But the car company kind of ran the actuarial model and said, well, we could recall 100,000 of these cars we produced and pay X amount of dollars, or we can just kind of wait and kind of cherry pick and pay these lawsuits out. And ultimately, that's what they did. They just paid the lawsuits out. So, unfortunately, I will say that is the nature of the game at times. But I will say this though, you can feel comfortable that at the end of the day, the decision to settle the case or to proceed forward, that lies with you, the client. I mean, and I would say, look, if you say, look, I am not settling this case, I want my day in court, I want to go to trial, then the attorney is duty bound to continue with that. Now, if they say, look, we want to settle this, that's a decision that really ultimately ends with the physician, ends with the doctor. So that's something that you can do. I mean, yes, you may have professionals that are saying we highly recommend that you settle this case because it's going to cost $30,000 to defend, and you could settle it for $5,000. Yeah, but you ultimately make that decision. It's nobody else's to make.
Most of the time, it never gets to this point of, a patient, filing a lawsuit and claiming malpractice, negligence, and that's great because that means there's, a lot of dentists trying to make it right. And most people, they're reasonable, and in my practice, I mean, it's very, we just don't have any problems. And if there is, it's always just a whatever. And but we as a profession right now, as dentists, and whenever I say dentist, I want us to qualify that for a second. We're going to talk about dentist, meaning like all the specialties and just general dentists as a whole. So oral surgeons, endodontists as such, etc., orthodontist, and then general dentist, pediatric dentist. And one of the things that has become interesting, because our universities do a great job giving us enough information to start practicing, single tooth dentistry. And as a general dentist, you can go beyond and learn a few more things postgraduate. And if you really want to make an investment in your education postgraduate and continuing education, Corey, you can really take it to the next level and really spend the time and the money and the effort to really becoming a little bit more than just a general dentist. You're providing a breadth of services that actually start to qualify as specialty services. So things beyond normal fillings and crowns, right? Let's just say that as a general dentist. And I think that our listeners would be great for them to hear, one, why do patients or why do dentists, general dentists, who are doing more of these procedures now, in the rural areas especially, because patients, and we are hearing that patients do not want to leave the general dentist practice to have procedures done. So therefore, the push has been through education, secondary education, postgraduate education, CEs, paid CEs, where, hey, you can provide this service in your office because patients don't want to leave. And therefore, you can keep those patients in. They're more likely to accept care. So now we have these general dentists that are now super general dentists, let's just call it that, and they're practicing in areas that once were just referred out, okay? And what do we need to do to protect ourselves? What are some of the things that go beyond just the normal filling? The patient that does general consent. They walk in, they sign papers, they agree to a certain practice standard by just signing in, and then they actually just sit in your chair and consent to having a filling done. Because have you ever signed a consent form, Corey? I'm not asking you to disclose your medical information here, but have you ever signed a consent form to have your teeth cleaned? Right? Most likely not. You've sat in the chair and provided what we were taught, general consent. So at what point, what's the point where you need to get an attorney to look at some things that you're doing and say, I'm a super general dentist here and I'm providing some care that's beyond the norm, right? What's beyond the norm? And what can we do to help some people that are listening to this really kind of decide, hey, I need to hire somebody. I really need to talk to some people about what I need to be providing to our patients so they understand what they're getting involved in.
I think that is, uh, hmm, I think that's something that you should, if you are finding your situation where you are providing these other more specialized services. I still am a big believer in really informed consent, and by that I mean, having a discussion with a lawyer that makes sure that you can, have them before they do a procedure that may be outside of the norm, as you're saying, making sure that is more than just the typical general consent. I mean, you're right. I don't ever recall going into any dental office to have my teeth cleaned or getting a filling done where I've ever really signed something. But I think making sure, trying to educate your patients as much as you can, and making sure that he or she knows exactly what you're doing. And yes, I mean, is a piece of paper or multiple pieces of paper going to always protect you from a potential lawsuit? No. I mean, that's not going to protect you from the what we talked about earlier in the show, the negligent acts that it could be easily prevented. But I do think, kind of going back to kind of again where we started about doing these other specialized procedures and making sure that you're good at what you do and you're striving to be better at other than being just a not there's anything wrong with it. I'm not saying that other than just a regular general dentist, you're doing other procedures. More referrals are coming in from out of state, from out of county, for just other than your typical referral. I do think that that's where the making sure that they understand, having a literally a sit down consult with the patient, saying this is what we're going to do, here's, and trying to really educate them and making sure that they, yes, provide consent, but it's more than just consent, because consent is such an ambiguous term. I mean, so I think what you do is it's more of an informed consent, and I think that's where you can be very specific as to your paperwork that they're going to sign, making sure they understand that this is a different procedure. This is a newer procedure. This is something that not a lot of people are doing in the area. Not a lot of people are doing it in the United States, or wherever it may be, depending on the specialized procedure. But I think that's where you get into the point of really consulting with an attorney to make sure that not only is consent given, but more it's really the term is more of like an informed consent, it's easier said than done, because at the end of the day, um, I'm sure that most people listening, I mean, even including myself, what we want to do is that we schedule multiple phone calls in the morning. We see how much we can cram into our schedules, and we're trying to get one patient in, or one client in, and the next client in, the next client in. And what we do is that we hurry, and we stop doing the things that I think are really the most necessary, and especially when it comes to, I think, some of the procedures that you're alluding to, is that sitting down with that patient and making sure that you're telling, John Smith, that John, this is what we're going to do. This is kind of a newer procedure. I'm qualified to do this because of my training that I've had postgraduate, and here are the risks that could come along with it. And making sure that they understand that this is a newer procedure, but spending the time with them to make sure that they are informed on everything that they can be. It's easier said than done, like I said, because at the end of the day, trying to get more people in and out of the chair, more people in and out of the office is sometimes what I know that I fall into, and trying to get better about that. But I think when you really look at it, making sure they not understand it to the level that you do, but kind of get a broad picture of like, hey, this is what we're doing. These are the known associated risks with this procedure, and making sure they sign something that will at least offer you some protection on that.
Yeah.
John, here's the thing, is we have a problem right now and in our profession of what qualifies as postgraduate education, Corey. YouTube University, right? And if you were, and we're speculating here, obviously, but the world has moved to hey, right now, let's look and see how we do this procedure, and then I'm going to go do it. And how is that? I mean, how is that different than reading a book, And does that qualify me? This is a textbook that I paid money for, highlighted and read and spent time in and educated myself and spent time, away from my office and I have some CE units that show that I've done these things, is that qualify me more than someone that's actually, John, reaching out to YouTube University or
Right.
wherever,
And
wherever?
I think that's the big issue that we see, and maybe why it's good to hear, because part of what, Corey, I know you can weigh in on is, the technical side of it of, hey, we need to be providing informed consent. But the piece that's harder, I think, to see, is so someone comes to you and says, Corey, I need your help to, getting some informed consent paperwork put together for this procedure that I'm doing, that I was trained to do. And of course, what you don't know is, well, how were you trained? And were you well trained? And what is good training? And because I think we forget that we are held to the same standard as general dentists as the specialist. And so, if we cannot provide the same quality of care as a specialist would provide, then we should be referring things to the specialist. And that is something that we, especially with the podcast and some of the things we've done with education, are finding that just these days there's less patience to just go, hey, I need to go and sit through 100 hours of continuing education before I do this procedure on a patient, because we're not really feeling like this risk is that high. But, when you do have that, letter show up, and that the feeling is going to be very different if you've got the training that you can say, hey, I am able to do this at a level that is the same as my specialist, or maybe even a higher level, or at very least you've got something more than just, I watched some videos this morning about this. And Corey, it sounds crazy, but it really is how it's going these days. In fact, it's going this way more than we would ever imagine. It's one of the reasons we started this show and why we've been doing it for so long. And listeners that, have been with us a long time understand that, it's bad out there. It's been bad out there, but it's getting worse. And I think it's very easy for us to kind of criticize that. But, in your world, Corey, I mean, when an expert gets up on this stand and you've got somebody who's, say, done 10,000 root canals. I'm just giving an example of something that, most people would be familiar with the term. And you've got somebody who has done their first root canal, and their training is, and maybe root canal is not a good example, maybe something they didn't learn in dental school. They're taking out wisdom teeth, right? But this is their first time they've ever taken out wisdom teeth, and they didn't have any formal training. They just maybe watched some videos on it, and they wanted to try it out. And, that expert gets up there and says, well, what happened here, this complication of this surgery, regardless of how good your informed consent was, Corey, how's that going to turn out? If you don't have the training, is what I mean.
Is that negligence?
I absolutely think so. No, I don't think there's any question, because, I mean, again, when we're kind of splitting hairs when we talk about medical negligence and medical malpractice, but I think that's no, I guess it would be. I mean, it'd be more of kind of a malpractice thing, because at that point in time, you should be aware of the risks is what you're getting into. No, I think that, when we look at a medical negligence thing going back, and I think I'll go back on what I said there. It is negligence, I will say that. But the type of negligence, I think when you look at that, we look at just medical negligence. I think that's more of an accidental type thing. So you know what you're doing, you just accidentally do something. But going back to, like I said earlier, and I said, medical malpractice intent. But I think a better word for that is not so much of an intent, but awareness. I think that's the thing. I think the awareness is a more properly used term that makes more sense. So you should be aware of the risks if you have someone else that's, like you said, taken out done 1,000 surgeries of extracting wisdom teeth, and you have one person that's only done it one time. I don't care how good your informed consent is. Like that's something, like I said, I mean, we're talking about things that are again highly fact specific. I mean, for the people, the professionals that are doing it the right way, that are making sure they're crossing their T's and dotting their I's. I think that informed consent is just another arrow in your quiver, if you will, about something that you can kind of protect yourself. But I don't think that any amount of informed consent in the world would help someone that has that lack of experience, because I think that that's something that when you look back at, I mean, and I say just simple negligence. I mean, it's just really at the end of the day, negligence is just a failure to exercise the standard of care that a reasonable, like similarly situated physician in that area would do. So I think that's basic negligence, because you can't do that. I mean, because you can't exercise the standard of care that a physician of just reasonable skills could do if you don't know what you're doing. So I think that is something. Hopefully that that's never the case for anybody listening. But I think that goes back to another thing that we're talking about: trying to maximize what your training and your experience, and make sure that and what you're good at, because I think that it comes down to kind of a personal decision as well, and not necessarily a personal decision, but personal and professional, knowing that knowing what's kind of in the proverbial wheelhouse, like what you're good at, not taking things that you're not comfortable taking, because what you're doing is, in that situation, if you're watching, as you said, YouTube University, if you're watching videos and you think that you can do it now, that's not going to end up well for you in the end, because you have no business, no training and experience that would allow you to do that. Now, eventually, maybe you can get there, but that's one of those things that you're just assuming that risk of a potential lawsuit. I don't care how good your paperwork is.
Yep.
John,
and that's what I think we need to hear. I think we need to hear that, because this is, this conversation has got us, I think, a lot of understanding of terminology, again, that we maybe have heard, but we don't always understand. But maybe more importantly, it's if you are well trained, you've got to be able to put things in place that help to give the correct informed consent. But if you don't have that training, it's very difficult when things go wrong, and they will go wrong, but it's a very different situation when things go wrong with somebody who's got the training, who's got the vetting, who's got the experience.
I tell you something else that's going on, and I want to ask one final follow-up question for Corey to finish up here. And John, something else that's going on. Of course, this might not be surprising to you. This might be the first time you're hearing it. But insurance reimbursement has gotten so low for certain procedures that when we're tied, as some people would put it, that have referenced to me in some ways, it's like the golden handcuffs, right, of insurance. You're in a practice where there's several insurances that you're in-network provider for. It's heavily insurance driven, and now you're in a situation where maybe the right thing they don't pay for, and actually you lose money on. And so therefore you neglect to actually, I don't know if neglect's the right word, you just don't treat it. You don't treat the disease. So that's actually going on right now in our dental offices, because office managers, from what I'm hearing, are looking at the bottom line and they're saying, hey, we can't do that anymore because we're not getting paid enough. And then the doctor's caught in between here and making the right call with the providers. Maybe it's a hygienist, maybe it's the dentist, maybe it's an associate, and like, man, you can't do that anymore. We're not getting paid on that. And that's a conversation that's going on. No one wants to even talk about this stuff, right? But we're being driven. Yeah. Speak to that.
That's tough. One thing I do want to follow up on, and I think one thing you all said, I don't think that, and I'll make it quick, but the lack of training and like I talk about the informed consent, those are not really mutually exclusive. I don't think that if you don't have the training, you can't give informed consent. period.
Mm.
Like that's because
Mm-hmm.
you can't, because you
That's
don't, you
good.
don't
That's the
know,
quote.
you don't know.
That's the quote of the episode.
That's it. If you don't have the
I
training, you
I
can't
think,
even do the information because you don't even know
yeah,
what you're doing to even
there's no
inform
way,
somebody.
because
Yeah.
exactly, like, there's just no chance.
great.
I mean, because you can't do that, and honestly, that's that's legal malpractice. If an
Mm.
attorney is if giving that, allowing a dentist to fill out something that he knows that he's not capable of doing, but that's a subject for maybe for another conversation. But
I love it.
but Wes, what you're talking about is that's horrifying, actually, because what that puts you all in such an odd position, because hypothetically you come in, and I don't even want to give a proper dental procedure because I would ultimately butcher that and misstate it. But if you come in and you see someone that has, I don't know, some infection going on, and
Periodontal disease.
so yeah, okay, something like that, okay, and you see that on a, whether it be an X-ray, or you see that just from a regular examination,
Yeah.
or however you would do that, you would see that, and you don't treat that. That puts you in a position of, maybe you can treat it, but it doesn't make sense for you to treat it because it's actually, you're not getting paid for it. And at the end of the day, it puts you in a bad position because you have the duty to make sure that you are informing that patient of what's going on. So that's a situation where the only way I know that you all can protect yourselves when it comes to that, if you find yourself in a position where you know that something should be treated, yet you do not want to do it, or you choose not to do it, you make sure that you let the patient know, like you have a severe onset of periodontal disease. If you don't treat this, you're going to start losing your teeth. All these other complications are going to happen. That's not something that we do. You're going to need. I'm going to need to refer you out for that. But I think what you do is, and you document that. You send a letter to the patient. You make sure that you do that, because ultimately what's going to happen, that's going to go back to that. Remember, we talked about awareness a minute ago in medical malpractice issues. You're aware of it, and you are choosing to not do anything about it. Now, you can get around that by saying, I'm aware that you have these certain complications going on. I'm aware of that. I'm making you aware of that. I will notate it in my notes and my patient chart, or whatever that may be, and I'll have my office manager send you a letter saying, you were examined for this today. That's not something that we do here at our office. You need to go find somebody else to do it. But if you say nothing, that's where you're exposing yourself, and it's understandable, because you don't want to do something. At the end of the day, you're not going to do it just to be doing it. If you're not going to get the bottom line, doesn't make any sense. I mean, I guess there are certain circumstances that'd be different, but I'm saying it just for the sake of this conversation, you have to tell these patients of what's going on, because if you don't, and you're aware of it, and you don't make them aware of it, that could be a medical malpractice situation that you're going to get sued for. And I think that's going to be very important that you let them know that. Now, again, there's so many other things that I know our time's running out, but there's so many other things like that the legislature has done to protect doctors, to certain certificates of good standing that have to be. It's almost like a vetting process before you even file a medical malpractice case. Now, I know we went from this side of the spectrum, from the lawsuit all the way to the trial, but there are certain things that happen before a lawsuit's filed that a plaintiff has to do to show that this case is even viable. Not necessarily winnable, but just viable. But I think, kind of closing out that thought, I think that it's something that it's a very scary situation, that you could be doing procedures that you're not going to get paid for. But I still think you have a duty as a medical professional to tell your patients that, look, you have this going on. Now, what you do from that point on, that's on you.
That's
But
right.
I'm making sure that you're aware of it, and we'll document that. So if someone wants to come digging through my charts and digging through my records, it's here. I told them about this on June the 1st of 2023. They chose to do nothing about it, but I've told them what to do. Then, again, that's protecting yourself.
John, this is great advice for an associate, new grad coming out, signing on. Maybe they're in a tough situation. They don't own the practice, right? They don't know the systems and protocols. I mean, they're a new dentist, and what happens if something like this happens? Well, you just heard it. Documentation. Diagnose it. Tell the patient about it. Don't hide it. Why hide it? It's their medical problem, not yours, regardless of where you're working.
Because what's going to happen is that you're going to have, going back to those experts, they're going to come in and they're going to say that you're a trained medical professional. You are trained to see these. You are trained to diagnose these. And if you do not diagnose these, that is neglect. That is something that you should have done. You're aware of this and you chose not to do it. So I think you're right, especially for the newer doctors, or that may not. But it's just about making sure that you're as transparent as you can be, not only in your own records but in your communication with your patients. Because I will tell you, it's not about, like, you can't hide it, because you can say that, well, I didn't notice it, but somebody else is going to say, maybe you say you didn't, but you should have, based on your experience.
That's great, John. Do you think that the dental guys have found our new partner in podcasting here with the dental guys, the dental guy's attorney right here. That's right. Right.
That's right. I think we can talk shop with this guy, right?
Yeah.
And
I love it.
And I think this is good because, many, again, as we kind of started, many of us are intimidated or not sure about this area, and we don't know what to do. And I remember a long time ago, a attorney friend of mine was like, man, I'm just going to sue you. So you kind of feel what it feels like to be sued. It's okay. Like, it's okay. Like, it's not, because in your world, Corey, like, this is just normal. It's like there's policies, there's procedures, there's things that, and if it's frivolous, it's frivolous. And there's things we can do. And it's, in our world, it's much the same as a patient coming in who knows nothing about what we do. And they're anxious about this procedure that, to us, we've done it 1 million times and it's no big deal. So I think it's very comforting when you can talk to somebody and go, hey, you know what, here, if you're doing this and this and this is going to put you in a good situation. Here's some things to watch out for. So, Corey, before we kind of close the show, just tell people a little bit once again about, where can they find out more about you if they're interested.
Can people hire you, Corey? Can people hire you? Because you want to. Here's the plug, Corey, right here. Here it is, because we really enjoyed having you on, and so
yeah, we really did.
Hey, if you live in Tennessee, right, Corey?
Yeah, Where are you at, Corey? How can we find out more about you?
Mm-hmm.
Well, you can. I'm in Greenville, Tennessee. I take cases really all over the Southeast, not just limited to Tennessee. So we practice in the neighboring states, but you can find us. Our website is collinsshipley.com, COLLINSSHIPLEY. You can look at kind of check us out on there and see kind of what we do, kind of who we are as a firm. But I just want to tell you too that I've thoroughly enjoyed this, and it was really fun for me. And there are so many things, and no, you're never going to feel comfortable when talking about legal stuff, just like I would never feel fully comfortable talking about dental stuff. But there are so many things that you all can do as a profession that make a lawyer's job a living nightmare trying to sue you. If you do certain things like we've talked about tonight, doing things the right way, documenting properly, making sure that consent is given, there are things that you all can do that make it so much less intimidating when you know that, look, I'm doing exactly the right thing, and just by educating yourself and just like talking through these things, some of the things that, yes, maybe I do them every day, but it's something that the majority of people don't really know that, and how you can protect yourself. And I think that's what the ultimate goal is. Us, as professionals, we want to do a good job, and we have a duty to do a good job. But at the end of the day, we have to make sure that we're protecting ourselves as well.
Yep. Very good.
John,
very good. Well,
Corey, hang on the line for just a second, and we'd like to talk to you just a little bit after the show. But man, John, let's go, right? This was amazing, because here we are talking about like the things that that matter, right? And because if you are an associate, or you're in a situation where you're being pressured, right, not to treat certain things, that's okay. Corey says that's okay, as long as you're informing the patient. And two, I think documentation is key. How well are your notes? Like, we can refine these things, and you heard it right there. If you want to make your attorney, right, job a living nightmare, what you can do is get informed consent. I love it, right? Document well. And you know what? I love what he said, John. Be confident. Be confident. text the dental guys tonight, 865-544-8954, and maybe it's not tonight. Maybe it's the morning. Maybe you're on your way to work. Don't text while you're driving because you might hire Corey, right? And that'd be bad. Okay? And all the links in the descriptions below to Corey's stuff and where you can reach out to him. John, love the show. And 2, John, I love our sponsor. I appreciate the Dental Crafters Network for sponsoring us and can't thank enough for them making this possible. John, tell us a little bit about where we're going and what's going on.
Yeah, so of course here we are, getting as we're going into kind of the midpoint of 2024. You just won't believe all the stuff we've got lined up. Man, it can be a monster, the show, in such a good way of just trying to fit it all in. So we're excited to bring you more great content coming up in the next few months. So like, share, subscribe, hit us up on the socials. Let us know what you want more of. Let us know who you want to see more of. We're excited to be on this journey with you guys, our listeners. Thanks for listening. And for Wes, I'm John, and we are the Dental Guys.